Hello everybody, it's Zach here from RealEstateLicenseWizard.com. Today I'm going to go over 38 real estate vocab terms pertaining to contracts. These terms are super important to know, and yes, they will show up on your real estate exam. Now after this video, if you want to study more real estate exam vocabulary, head to our website. There we have a completely free set of real estate exam vocabulary flashcards. We have over 350 real estate terms, all with detailed explanations and descriptions, so definitely check that out if that's something that interests you. Link down below. Anyways, buckle up and do me a favor and hit that like button if you're eager to pass the real estate exam. Without further ado, let's jump right into it. Alrighty, let's start with valid contract. What is a valid contract? So the way this is going to work is I'm going to give you guys just a couple moments to think about it in your mind, come up with what you think the definition is, what you need to know, what you need to understand for this term. And then after the few moments that you get, I'll go over the explanation, the textbook explanation of this term. So go ahead and take a few moments to think it over, starting now. Alrighty, hopefully you came up with your answer. So what is a valid contract? Well, a valid contract meets all legal requirements of a court of law and is legally enforceable. So what exactly does that mean? Well, essentially, we want a valid contract. That's good. That means all legal requirements are met, essentially in the court of law. What are those requirements? Well, there's actually 4 of them. We will talk a little bit about these in this video, but really because we're just kind of doing the basic vocabulary terms, I'm not going to get too thoroughly into this, but essentially there's 4. One is the age. They have to be 18 or older. It has to hold a legal lawful purpose. There should be clear and specific consideration, which we'll talk about a little later. And then there needs to be mutual consent. So if all those things happen, we have a valid contract, and yes, we want that. A valid contract is good. We want a legally enforceable, proposition or, system in place so that we can have fair and safe transactions. Which leads us to the next one, which is void contract. So take a few moments and think about what a void contract is. Alrighty, so what do you think a void contract is? Well, a void contract is one that lacks all or one of the elements that make a contract valid. The contract is invalid at the time of its establishment and is not legally enforceable. So what exactly does that mean? Well, void contracts are not contracts because they lack an essential element of a contract and are thus unenforceable. So remember just a few moments ago when I was saying there's those 4 legal requirements. If a quote-unquote contract is lacking one of those elements, it would be considered void. It doesn't exist because, again, it's missing that essential element and is thus unenforceable. So it's not a contract. So I know that contradicts itself, right? Because it's a void contract and it's in the name, but technically void contracts are not contracts. So just keep that in mind. And this leads us to our next one, voidable contract. So take a couple seconds, think that one over. Alrighty, so what is a voidable contract? Well, a voidable contract is a legal agreement between 2 parties that may be unenforceable for any number of reasons. So if you'll notice, this interpretation is a little bit more vague. Void contracts are a little bit more specific. Voidable are not. Voidable contracts have the necessary elements to be enforceable, so they appear to be valid, but can be rejected by one party if the contract is discovered to have any number of defects. So that's the difference there. Again, with a void contract, the one that we just went over before, they're not contracts at all, whereas voidable contracts are legal. However, they may be unenforceable for any number of reasons. Again, they could appear valid on paper, but be rejected by one party if the contract is discovered to have any number of defects. So hopefully you understand that, and that's going to bring us to the next term that we need to know, bilateral contract. All right, so take a couple seconds to think about what you think that means. Alrighty, so what is a bilateral contract? Well, you should know this one by now if you know your basics in contracts. A bilateral contract is an agreement between at least two people or groups, and most business and personal contracts do fall into this category. So obviously, bi stands for two or more. So again, that's where the bilateral phrase comes into play. And essentially all business and personal contracts are going to fall into this category, or most, I should say. Which leads us to our next one, unilateral contract. So what is a unilateral contract? Think about that. All right, well, if you got bilateral, you should know unilateral. A unilateral contract is a one-sided agreement. Only one party makes a promise to perform. One party pays the one party. I keep saying one party, but one party pays the other party to perform a certain duty. If the first party fulfills the duty, the second party is obligated to transfer the specified funds. Now, it's worth noting with this one that second party is not obligated to do that action, and that's the difference between a bilateral and a unilateral contract. Is a bilateral contract essentially two people agree to make promises, whereas with a unilateral contract, just one person is agreeing to make a promise. So an example that I always bring up for this is, let's say you have a lost dog and you put on a poster saying, hey, $500 reward for whoever brings me, my dog. Essentially, you're creating a unilateral contract. People that go by and walk by on the street, they see that sign, they're not obligated to, perform that action. They're not legally obligated to look for your dog. However, you may be legally obligated to pay that person if they find the dog. So again, that's the difference there, that unilateral versus bilateral. Alrighty, next term, express contract. Alrighty, so take a moment, think about this one. Alrighty, so what is an express contract? Well, an express contract occurs when both parties legally establish an agency relationship. In other words, they sat down and wrote a contract stating their relationship. This is the most common method of creation for agency relationships. Try not to overthink this one. I think a lot of people get caught up with what actually is an express contract, but for what we need to know and for what you guys need to know specifically for the real estate exam, just understand that when you hear express contract, just understand that that's when it's legally establishing an agency relationship. Don't overthink this one. All right, next one, offer. What is an offer? So take some time, think that one over. Alrighty, so an offer. An offer is a proposal made by one party to another expressing a willingness to enter into a contract on certain terms. Pretty straightforward. You have an offer, and then you have the next term, which is acceptance. So acceptance is our next term, so take some time, think that one over. All right, what is acceptance? Acceptance is the unconditional and unqualified agreement by the offeree to the terms of the offer. When an offer is accepted, it becomes a binding contract. So again, that's where we have that offer plus acceptance. So these terms kind of go together, but you do need to understand them and how they operate. All right, next term, counteroffer. So what is a counteroffer? So take some moments and think that one over. Alrighty, a counteroffer is similar to a purchase agreement. If a counteroffer is made, the original offer ceases to exist because legally the seller has rejected it. So hopefully that makes sense. Again, we have offer, we have acceptance, and we have counteroffers, and we have a couple other terms that are, kind of in the same boat, but essentially these do go together. When you think of counteroffer, it's essentially the same thing, except what we really, really, really need to know, because this comes up all the time, is if a counteroffer is made, the original offer ceases to exist. Because again, that essentially means that the seller rejected it. Super important to know. You can't, have a counteroffer and then be like, oh, you know what, never mind. I want to go back to that original offer. No. I mean, it can happen. It can be that way, but not legally. It would have to be restructured. It would need to be redrawn up. That original offer would need to be recreated. You can't just say, oh, never mind, let's go back to that offer. All right, next one, consideration. So what is consideration? All right, so hopefully you understand, hopefully you thought of something good for consideration. Well, consideration is something of value given by one party to another in exchange for something else. Consideration is an essential element of a valid contract. So remember earlier, I was talking about those four essential elements. Again, there needs to be consideration. Clear and specific consideration must be included in these agreements to be valid. So just keep that in mind. That's one of those essential elements to a contract. Alrighty, next one, mutual agreement. So what is a mutual agreement? Think that one over. Alrighty, a mutual agreement, essentially the meeting of the minds between the parties to a contract. It requires that the parties understand and agree on the essential terms of the contract. So this is pretty straightforward here. If you have mutual agreement, again, that's a good thing. You want that. That means that both parties are agreeing to this contract. Don't overthink this one. Pretty easy. All right, next one, revocation. All right, so think that one over. All right, what's revocation? The act of withdrawing an offer before it is accepted is revocation. An offer can be revoked by the offeror at any time before acceptance. So, quick example, let's say you and your client put in an offer on a house for $125,000, small, home, and basically your client then finds another house and they're like, oh, you know what, never mind, I want to put an offer on another house, and the original owner of that first house has yet to accept the offer. You can essentially revoke that original offer before acceptance is made, and you're good to go. No strings attached. So pretty simple there. All right, next one, breach of contract. What is a breach of contract? Think about that. Alrighty, so breach of contract is the failure to complete an agreement per agreed terms. Pretty straightforward. Breach contracts are bad. You do not want to breach contracts. It typically means a lawyer might get involved, lots of fees, not good. So try and avoid that. All right, next one, agreement of sale. What is an agreement of sale? Think that one over. Alrighty, so an agreement of sale. That's the form that states the buyer consents to purchase the property and the seller agrees to sell that property with the terms and conditions illustrated in for both parties. Now, if you are in that boat where you're like, wait a second, what's an agreement of sale? That definition sounds familiar, but I don't get that. Well, that's because this is also known as a purchase agreement, an offer to purchase, or earnest money agreement. Really, those things are interchangeable. They're all the same term. It's just a matter of regional things. But yeah, so just keep that in mind. Purchase agreement, agreement of sale, offer to purchase, or earnest money agreement. They're all the same thing. Essentially, it's just a form that just shows that the buyer consents and the seller consents. Again, it's an agreement of sale. The meaning is in the definition. All right, next is listing agreement. So take some time to think about that one. Alrighty, hopefully you understand what a listing agreement is, because when you get your license, chances are you're going to be dealing with a lot of these. So a listing agreement is a document in which a property owner contracts with a real estate agent to find a buyer for the owner's property. Now, a listing agreement is really a real estate contract in which the property owner contracts with that real estate agent to find a specific buyer. Now, the owner executes the listing agreement to give a real estate broker the authority to act as the owner's agent. And that's obviously where we get the term agent, in the sale of the owner's property, for which the owner agrees to pay a commission. So again, don't overthink this one. Pretty straightforward. Listing agreement is one of basic terms, one of the basic contracts really that you'll be using and you'll see in your real estate career. All right, next one is open listing. What is an open listing? Alrighty, so an open listing is a real estate agreement where property owners sell their home on their own or using multiple real estate agents. In this type of non-exclusive listing agreement, the seller is not beholden to any sole agent. Multiple agents can compete to find a buyer and receive a commission. Again, this is one of those terms that you'll see show up on the exam. Just try and think of it simply. Basically, an open listing is truly open. A real estate agent can find the seller or the owner can find a seller. It doesn't matter. It's listed on the market. It's completely open. All right, next one is exclusive right to sell listing. So what is an exclusive right to sell listing? Think that one over. Alrighty, so one broker is appointed as the sole agent of the seller and has exclusive authorization to represent the property. That is an exclusive right to sell listing. Now, it's worth noting here, the broker receives a commission no matter who sells the property while the listing agreement is in effect. So again, just remember that. If I mention a note like that, it's typically for a reason. They like to ask that question a lot. So again, remember that. Broker receives a commission no matter who sells the property while the listing agreement is in effect for exclusive right to sell listings. All right, next one. Exclusive agency listings. This one is different. So think about that one. Alrighty, what is an exclusive agency listing? Well, an exclusive agency listing is an agreement where the seller gives a real estate agent the exclusive right to sell their home, but the agent only gets a commission if they find the buyer. So this is different. This is different than the exclusive right to sell listing, because again, with that one, the broker receives a commission no matter who sells the property while that listing agreement is in effect. With this one, it's not the case. The agent only gets a commission if they find the buyer. All right, next one, listing with an option. Another popular contract discussion point. Think about that one. Come up with it. Alrighty, so what is listing with an option? Well, listing with an option is a type of listing for a real estate agent or broker to purchase the particular property. So believe it or not, it is legal for a real estate agent or broker to buy listed property directly. However, it needs to be specified in the listing agreement. So of course, that's the big note there. It needs to be specified, and that's kind of why this thing exists. So again, listing with an option, it's just a type of listing for real estate agents or brokers to purchase a particular property. All right, next listing, next real estate contract term. What is it? It's net listing. What is net listing? Think about that one. Alrighty. What is a net listing? Well, a net listing is when an agent agrees to sell an owner's property for a set minimum price. Anything over the minimum price belongs to the agent as commission. Now remember about this term. In some states, net listings are illegal in order to protect the consumer, or in other states, the agent must disclose his or her exact commission in the listing price. So you might be thinking, sitting there like, oh, well, if it's illegal in my state, I don't need to know it. Don't worry about it. No, 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 no. Just because it's illegal in your state does not mean you don't need to know it. In fact, I would argue that you do need to know it even more. You do need to know this term even more because the exam likes to test you on these illegal situations or these illegal contracts and things like that. So again, super important to understand that what a net listing is first, and then two, if it's legal or illegal in your state. And if you do need to find that out, you can check out our site for that. We do have an article on that. All right, next one, implied contract. What is an implied contract? Think about that one. Alrighty. An implied contract is a legally enforceable obligation that arises from one or more parties due to the party's actions, conduct, or circumstances. Now, it has the same effect or the same legal effect as an express contract, which is obviously a contract between two or more parties that is willingly entered into and agreed upon verbally or in writing. An implied contract is presumed to exist but does not require written or verbal confirmation because, again, it's implied. Now, you're probably sitting there wondering, because I know when I first learned about this stuff, I was, well, what exactly are you talking about? Don't worry, just understand the basic terminology for this, the basic terminology for implied contract. What you really need to know is these next two terms, which go directly with implied contracts, which leads us to the next one, implied in fact contract. So again, there's two versions of implied contracts, implied in fact and implied in law. And this is the easiest way to understand this, is just to understand these two. So take a moment, think this one over. Hopefully you know this. If not, don't worry, I'll explain soon. So think about it. Alrighty, so what is implied in fact? Well, an implied in fact contract is created when two parties act as if they've reached an agreement or a type of implied contract made through non-verbal behavior rather than exact word. So implied in fact contracts have the same properties as express contracts. There is an offer from one party that the other party accepts. Consideration exists, and both parties desire to enter in a contract. The provisions of an implied in fact agreement are inferred from the conduct of the parties rather than being stated explicitly or in writing. So hopefully that makes sense. And then there's this other version, which you need to know as well, which is called implied in law. So think about that one, implied in law contract. Take a few moments, think about that. All right, so what is implied in law? Well, sometimes known as quasi-contracts, are the final option for judges faced with a scenario in which one party is using the other. This approach is used by courts to reward someone for services rendered not because one party offered, or even if neither party meant to enter into a contract, but because the person who got the products or services would be unfairly enriched if they were not compensated. In plain terms, an implied in law contract is a legally enforceable agreement that neither party intended to make. Courts accept an implied in law contract in cases where one party would otherwise be, as it says here, unfairly enriched at the expense of another party, even though the parties involved did not intend to make it. So again, that's the difference between those last two, is the implied in law. Essentially, the parties did not intend to make this contract, and that's why it's called a quasi-contract, because the judges are faced with a scenario and this is pretty much their only option to make things fair. Whereas implied in fact, essentially, it's a non-verbal agreement that pretty much, these parties want that contract. However, it hasn't been, specified in writing or, stated explicitly, things like that. So that's the difference between those two. Hopefully that makes sense. I know that's a lot, and we do have specific videos on each one of those if you did get caught up on that. So just keep that in mind. All right, next one, lease option. What is a lease option? So take some time, think about that one. All right, so a lease option, commonly known as a rent-to-own deal, is available to tenants who want to acquire a rental property. A lease agreement option allows a renter to acquire a property after a defined renting period. So essentially, this is just one of those, real estate contracts that you need to know. One of these leasing options that shows up pretty often. Don't think too much about this. It's just, again, included in this scenario. All right, next is executed contract. So take a moment, think about that one over. All right, so what is an executed contract? Well, executed contract is when contracting parties have signed a contract and both parties have done all they promised to do. It is then called executed or an executed agreement. Now, don't worry, because I already know there's already people that are thinking, what exactly does that mean? This is going to make a little bit more sense once you understand the next two terms. So just keep that in mind if you're completely lost. Hopefully you understood this and you're like, oh, Zach, I got this. I know that. No big deal. All right, next term, execution date. So what is the execution date? Think about that for a moment. All right, the execution date or date executed is the day the contract is signed. It's not when it is completed. It is not when it is completely, finished or acted upon. It is when the day the contract is signed. So when it's the execution date, that means that it was signed that day. Hopefully that makes sense. All right, next one. And this is where all the puzzle pieces are going to come together for you guys that don't understand. Executory contract. What is an executory contract? Think this one over. If you don't understand, no biggie. I'm going to explain it all in a moment. So just think about that. All right, an executory contract is a contract in which the terms are set but will be fully completed later. Okay, a brief recap on those last three, and don't worry, I'll move on really quick, but I know I might not have explained it fully enough because this stuff can be super complicated, so don't worry. Okay, so a question I get asked all the time is, can an executed contract be an executory contract or vice versa? And essentially what you need to understand is that an executed contract is when all parties have signed it and all parties have done all they promised to do. So that's like the final, that's it. When it's executed, it's done. You don't have to worry about it. An executory contract could and ideally would eventually be an executed contract. An executory contract just essentially means that the terms are set, but they're going to be fully completed later, meaning that they're going to be fully executed later. So that's really the big difference there. And hopefully you understood that. And if you did not, I have full videos explaining this because I know this is super complicated. And for the sake of time, I'm going to move on. But again, don't be afraid to look into those other videos where, in my opinion, I gave a better explanation. So I apologize. I apologize for this one today. But yeah, just keep that in mind. All right, time to move on. Contract clause. What is a contract clause? Take a few moments to think about that. All right, this is pretty straightforward. A clause identifies a particular section of a real estate contract. Clauses are sections in purchase agreements, deeds, mortgages, and more. All right, next one. Habendum clause. All right, take a moment, think about that one. All right, so what is the habendum clause? Well, the habendum clause is the statement in a real estate contract that describes the rights and interests being given. It almost always begins with the words to have and to hold. Put simply, the habendum clause tells the buyer or leasee exactly what they are getting. All right, next one, alienation clause. Take some time, think about that one. All right, so what is the alienation clause? No, it does not have to deal with Area 51. Yes, I tell terrible jokes. Yes, I'll be here all weekend. And the explanation for alienation clause is a provision in a mortgage or deed of trust signed with the lender that states that the borrower must pay the mortgage in full before the borrower can transfer the property. This just means that the clause prevents new buyers taking over an existing or previous mortgage. All right, next one, defeasance clause. So take some time, think about the defeasance clause. Alrighty, so what is the defeasance clause? Well, the defeasance clause is a required contract provision that ensures that the title for the property is transferred to the buyer once the mortgage is fully paid off. Pretty straightforward here. Basically, it's the clause that specifies that the lender must surrender all rights to the property once the mortgage is paid. Now, it's worth noting that this provision only exists in certain states. For more information on that, check out the video where I talk a lot about the defeasance clause. And that's super interesting. If you're just interested in that, I encourage you to check that out. All right, acceleration clause. What is the acceleration clause? Think that one over. Alrighty, so the acceleration clause is a real estate contract provision that requires a borrower to repay all of an outstanding loan if upon breach of contract. This basically means that if a borrower breaks any terms of their mortgage, the lender can demand an accelerated payment. And again, good thing we learned about a breach of contract earlier, because you kind of understand, how that works. If one of those things happens, something happens where there's a contract breach. Essentially, this provision ensures that there's that accelerated payment, or the lender can demand an accelerated payment. All right, next one, the prepayment penalty clause. Take a moment, think about that one. Alrighty, so the prepayment penalty clause. What is that? Well, that states that a lender can penalize a borrower if the borrower pays off the mortgage much sooner than usual. This just means, as it sounds, if someone pays off their mortgage too soon, they could be slapped with a fee. Now, it's worth noting that prepayment penalty clauses are becoming less common, but they are still relevant. And typically, they're not a great thing. You don't want a mortgage with a prepayment penalty clause. All right, next one. Subordination clause. Take some time, think about that one. All right, so the subordination clause is a clause in a real estate contract which establishes an order of priorities of financial claims or liens. Now, this clause, seen commonly in refinancing, just establishes who gets paid first in case of foreclosure. All right, next one, release clause. Take a few moments to think about this one. All right, what is the release clause? Well, release clause is a contract provision, typically in a blanket mortgage, that allows for the freeing of all or part of a mortgage from a claim through a proportional or full amount of the mortgage being paid off. All this does is allow investors to pay off a specific portion of their blanket mortgage versus all in one lump sum. So, for example, if owner has multiple properties that they're paying mortgages on, they could opt in for a blanket mortgage, which would combine those. And essentially, with this clause in place, if they paid off maybe 25% of that total mortgage with 8 houses, maybe they would get 2 of those houses paid off. Essentially, that's how it works. You might be wondering, why would anyone want to do a mortgage like that? Well, that's for a whole nother conversation, but essentially, the short version is that it allows easier payments and investors to kind of focus on different things a lot easier when you just have to pay one mortgage versus 8. It's a lot of simplified version, and often you get a better interest rate when you do that and things like that. All right, next term, amendments. So what is an amendment? Take some time to think about that one. Alrighty. An amendment is typically used to change something that's part of an original contract. So think of amendments as modifications to an agreement. All right, next one. Addendum. What is an addendum? Take a few moments to think about that. Alrighty. An addendum is used to clarify and add things that were not initially part of the original contract or agreement. An example of an addendum being used would be if the parties wanted to add something to the original document. For instance, an individual who purchased or is purchasing a house may not want to purchase all the furniture that is being left behind. However, maybe, after thinking about it later, they change their mind, then they could use an addendum. Now, an example of an amendment would be if someone wanted a contract to end in 6 months versus 8. So they amended it to 6 versus 8. So one changes terms and one adds them. Does that make sense? Hopefully. So that's the difference there between those last two. All right, next one, novation. What is novation? So think about that one. All right, the legal procedure in which an original contract is terminated and replaced with a new one. That's novation. This is the legal process, which makes it possible to transfer all contract benefits and liabilities from previous parties to a set of new ones. In plain terms, it's a simple way to replace an old contract with a new one while maintaining most or all of its original properties. All right, next one, contract assignment. Oh, okay, this is a good one. All right, so think this one over. All right, so what is a contract assignment? Well, a contract assignment occurs when a party assigns its contractual rights to a third party. Assignments make it possible to transfer all contract benefits from previous parties to a set of new ones. Now, you might be thinking, okay, what's the difference between that and novation? Well, unlike novation, that occurs to replace an old contract with a new one. Assignments transfer the rights from the original party to a new one. There is no new contract. It's the same one, but with different parties. So hopefully that makes sense. And we did it, guys. That was 38 real estate contract vocabulary terms. Hopefully you guys enjoyed. Hopefully you learned something today. For more videos like this, click here and click here to subscribe. Thank you guys so much for watching. Don't forget to check out our website for more. Until next time, see ya. Bye-bye.